You are watching PR English Shorthand Dictations YouTube channel.
This is English Shorthand Dictation number 372 and the dictation speed is 120 words per minute. Ready? Start. We have carefully considered the submissions made across the bar. We have perused the evidence of the material prosecution witnesses with the assistance of the learned counsel appearing for the appellant. At the outset, it must be noted here that the prosecution case is not based on circumstantial evidence. It is specifically based on the evidence of the alleged eyewitnesses PW1 and PW3. Apart from the eyewitnesses, the prosecution relied upon the recovery of the alleged weapon of offense at the instance of the appellant and the fact that the appellant disclosed the place where he had thrown the dead bodies. As neither PW1 nor PW3 supported the prosecution, what remains to be considered is only the evidence of alleged recovery at the instance of the appellant. According to the prosecution case, the offense occurred after the evening of 4th January 2004 and before 9 a.m. on 5th January 2004. According to the versions of PW15 and PW20, the appellant allegedly made a disclosure statement on 9th February 2004. According to both the witnesses, the appellant disclosed that he had kept a country-made pistol along with two cartridges wrapped in a polythene bag in front of the plaza building. Though PW15 deposed that the appellant disclosed that the country made pistol, along with two cartridges wrapped in a polythene bag, was kept underneath the earth in the eastern corner of the open space. PW20 did not specifically depose that the appellant disclosed that the articles were kept underneath the ground. PW15 described how the appellant took the police to the park in front of the plaza building. He did not state that the recovery was made after digging the earth. He stated that the appellant led the police to the eastern corner of the park and showed the country made pistol of 315 bore along with two cartridges. Even PW20, in his examination in chief, did not disclose that recovery was made after digging, though Memorandum Panchanama of Recovery recorded that the weapon was recovered after digging. Both PW15 and PW20 have not deposed to that effect. Though both the police witnesses initially stated that no independent witnesses were available, PW20 stated in his cross examination that there were public witnesses available who were not found interested. More than one factor renders the prosecution theory regarding recovery very suspicious and doubtful. The first factor is that the recovery was all allegedly made 1 month and 4 days after the occurrence. Secondly, the recovery was made from open space in a garden. Thus, the place was easily accessible to many. Thirdly, neither PW15 nor PW20 have stated that the weapon and cartridges were buried underground and were recovered only after digging. Lastly, though independent witnesses were available, they were not made witnesses to the Panchnama made pursuant to the alleged statement made by the appellant. As the recovery of the weapon at the appellant's instance cannot be believed, the decisions relied upon by the learned counsel for the respondent are not significant at all. She relied upon the decisions which hold that in certain cases a conviction can be based on the recovery of the weapon of offense at the instance of the accused. According to the prosecution case, on 9th February 2004, the appellant led the police party to a place where he had thrown the dead bodies. However, dead bodies were already recovered on 5th January 2004. Therefore, the place from which dead bodies were recovered was known to the police long before 9th February 2004. Consequently, it cannot be said that there was a discovery by the appellant of the place where dead bodies were kept. Therefore, that part of the statement of the accused which records that he would show the place where he had thrown the dead bodies is not admissible in evidence under Section 27 of the Indian Evidence Act 1872. The complainant and real brother of deceased Pawan deposed that he suspected the involvement of one Naresh in the offense. PW20, in his cross examination, admitted that he did not make any investigation whether there was any enmity between the said Naresh and the deceased. He admitted that one Mukesh was a personal friend of the deceased Pawan. He pleaded ignorance about the correctness of the suggestion that Mukesh had murdered Naresh. The police have not investigated the role played by the said Naresh, who, according to the brother of the deceased, was on inimical terms with the deceased. When, according to the family of the deceased, Naresh was the suspect, police ought to have investigated the role played by Naresh. There is yet another critical aspect of the case. PW15 and PW20 have not stated in their examination in chief how they became aware that PW1 and PW3 were the eyewitnesses. For all the aforesaid reasons, the evidence of recovery of the weapon at the instance of the appellant cannot be accepted as reliable. Moreover, the findings we have recorded above create a serious doubt about the truthfulness of the prosecution case. Therefore, in any case, the benefit of the doubt must be extended to the appellant. It can also be said that once the evidence of recovery is disbelieved, it was a case of no evidence as the eyewitnesses did not support the prosecution. Accordingly, the appeal must succeed. The impugned judgment and order dated 2nd May 2011 in Criminal Appeal number 942 of 2007 passed by the High Court of Punjab and Haryana and the judgment and order dated 19th September 2007 in Sessions Case number 13 of 2004 passed by the Additional Sessions Judge Gurgaon are hereby quashed and set aside insofar as the appellant Kishan is concerned and he stands acquitted of the offences alleged against him. We direct that the appellant shall be immediately set at liberty unless his custody is required in connection with any other case.